up with is a process where your applicants each go through the process of securing a location, getting some sort of option from a landlord, and then if you have more applicants than you have permits, you have to use a relatively subjective process to choose between the applicants. And the process also was difficult because it combined several different things into a single competition. Who was allowed to, it combined a decision about who would be operating these businesses with a discussion of where they would be and what they would need to do to be compatible with your zoning in your neighborhoods, and a separate discussion about the safety and security. What I'm recommending is that you switch to a regulatory process, which to the extent possible makes your process for commercial cannabis businesses look like your processes for other kinds of licenses. For example, I don't know if you have taxi licensing, but if you did, the common way those are licensed, and any other kind of heavily locally regulated business. And then also a zoning process. So what you're switching into is track one is deciding who can operate these businesses and doing checks on their safety and security plans. And then track two is doing conditional use permits and similar planning commission documents regarding at a particular location, what do you require in order for a business to operate at that location. So I'm going to talk about the two different sides separately. First is licensing, which is the permit. The permit is required to operate under this ordinance to operate a cannabis business, where there are a limited number of permits. So you have 3 adult dispensaries, for example. A lottery would be held to determine who gets to apply for the slot. So the notion would be that once a slot opens up, and mind you, if you keep 3 slots, then all 3 slots for both cannabis for the adult are actually already issued. So there isn't going to be an open slot next year anyway. But when a slot opens, the administrator will essentially say, we are going to have a pre-application lottery. You can, and as long as you turn in a pre-application by the deadline, we will then draw from those applications the number of slots and choose who can then go through the rest of the process to apply for a permit for the slot. Then the permit under the licensing scheme can only be issued after all owners and managers have obtained a background clearance from the police department. The business has obtained their state license for whatever activity they're going to do. The business has an approved safety and security plan that's gone through the police department, has passed inspection under that plan to show that they're complying. And the sites comply with all zoning requirements, including any conditional use requirements if this is something that needs to go before a hearing before the planning commission. The permits have a 1-year term, but they're renewable basically by renewing the background clearances. So so the people involved get checked out once a year under this scheme, and having another look at the safety and security plan and another inspection. Managers and owners can be swapped in and out of a permit as long as they're able to get the background clearance. But a permit is tied to a location. If a business is moved to a different location, it essentially needs to apply for a new regulatory permit. The slot, so one of those 3 slots for the dispensary, will stick with the permit as long at the new location, as long as the old location shuts down, as long as the old location has been in business and hasn't been shut down for more than a certain number of days in the last 6 months. A single license can authorize more than one type of activity at a location. So you could have both a adult and a medicinal at the same location, but anytime you add a commercial cannabis activity to a license, that requires another application process. Okay, then separate set of rules is zoning. These are restrictions on what activities are allowed in the city and would mirror your the way your zoning code usually works. This ordinance would leave in place the existing restrictions in the existing ordinance that list which activities can be in which zones. That's certainly something that we can change. We also can make activities a conditional use rather than a permitted use in zones, which would ensure that that type of business would have to go to a planning commission hearing, as opposed to being an of right project where it wouldn't. The zoning process would work just like a zoning process for any proposed new use of the parcel. It's about what can be done at the location and how the location can be improved, but not about who can do it. Right now, the zoning rules in the new ordinance are somewhat skeletal. And the reason for that was partially to get some input from the commission and the council about how it would like us to proceed, and also to have an opportunity for us to run this by community development and other departments. Now, the operational rules, as opposed to the physical improvement rules for the business, are basically called safety and security rules. They are outlined in the ordinance, and each business would have to, as part of the regulatory process, submit a safety and security plan that in more detail says how it will comply with those rules. Once that plan is approved by the police chief, it's binding on the business, and the business is subject to inspections. Violations are handled as a code enforcement matter. So under your existing scheme, there's this notion that every year you look back at the permit you've issued and decide whether or not to allow the business to stay in business. Here, it works like it would for other businesses in the city, where the business license renews as a matter of course, as long as you pay your annual tax or paying your taxes on time, and in this case, do your safety and security plan and your recheck of the background. And if the business is violating any of the rules in safety and security plan, you would not handle that by revoking a permit. You would handle that necessarily. That would be a last resort. The main way you would handle that would be through code enforcement and through fines and citations. The business license tax, right now, you have a special tax for cannabis businesses, which there aren't a whole lot of rules in your ordinance about how it should be administered. The new ordinance essentially has it so that it mirrors all the processes of your business license tax. Right now, it has it by default at annually, but that probably would be something I'd like to change to having it collected quarterly, because it turns out that's how you're currently doing it. And it also would allow the administrator to change the frequency or method of collection as necessary. We do need to also make a decision about whether the cannabis tax is in addition to or in lieu of your basic business license tax. One issue that came up was the treatment of non-retail businesses. Your existing permits so far are all for dispensaries, which are what I call retail business, but your current ordinance allows a number of other types of cannabis uses, including cultivation, testing, distribution, and manufacturing. This ordinance would put a moratorium in place until July 1st, 2021 on permits for non-retail businesses. The reason for doing that is to allow the city council to revisit the operating and zoning rules for those businesses. Because right now what we have is something that was more or less copied from some other city. And it would make sense, I think, to fully revisit that, and you don't have time to do that before the August deadline for getting this on the ballot. Alternative approaches to doing the moratorium would be to write new rules into the new ordinance before August, to copy the rules from the existing ordinance into the new ordinance, or to just prohibit non-retail uses, and then the council can choose to add them later with whatever restrictions it likes after the ordinance has been passed. Permit limits are kind of a fundamental feature of your existing regulatory scheme. So you have allowed 3 medical dispensaries, 3 adult dispensaries, and an unlimited number of other cannabis businesses. I just want to point out that most of the complexity of your existing process comes from that 3 permit limit. And that's what makes this so much more complicated than opening any other sort of business in the city, is that right now you have a limit of 3 permits, and if you have more than 3 applicants, you get into a contest for who will get the 3 permits. One way to avoid the complexity would be to treat this more like other businesses in the city, and say we're not going to have a limit on the number of permits of each type. Instead, if people are able to pass the regulatory rules for who can operate one of these and are able to pass the zoning requirements, then they can open the business regardless of where there are other ones in the city. That would allow there to be more than 3, but it's not clear that having 5 as opposed to 3 would be particularly detrimental. And also issuing 3 permits doesn't necessarily mean that you have 3 businesses even, because some of these permittees are likely to fail, and having to go through a new competitive process every time something doesn't fail, or every time something fails or doesn't open, can become very burdensome. So you might actually get more like 3 of each kind of business if you eliminate the limits altogether. But that's not something that's been done in this ordinance. That's just something to bring up. Another thing that you might want to look at is if you're going to have limits on the dispensaries, why not have limits on the other uses? Though the other uses certainly can be dealt with through zoning regulations and be unlimited. In terms of amendment, current ordinance can't be amended by the council, which makes it hard to tweak the process. The new ordinance would allow amendments by the council. The one amendment that could not be done is voter approval would be required to raise tax rates above the maximum state of the ordinance. You could include limitations on what sort of amendments you want to allow yourselves to do, rather than require to go back to the voters. Existing permits would continue under the new ordinance and count against the limits. To the extent an existing business with an existing permit isn't meeting the zoning requirements that are in the new ordinance, it would be a legal non-conforming use, just like any sort of business that opens before a change to zoning rules. And as we've mentioned a few times, deadline down the November ballot is August 7th. And if we miss that deadline, then we would need to do this at a different election, which, given that you've already issued all of your retail permits, may not be that big of a deal. It could be quite practicable to decide to slow this process and not put it on the August ballot. That's my presentation. And if I can figure out how to get back to Zoom, I'm available to answer questions.
Okay.
Here we go.
Go ahead, anyone, just raise your hand. Victor, go ahead. You're muted on your end, Victor.
Now I'm not.
Good evening, Victor.
Thank you, Mark. I just have a couple of questions in the ordinance itself on page 11, finances.
Mm-hmm.
And in the second line there, it said it can operate at any location, occupy a structure, or use personal or real property of any kind. Does that mean somebody can have one of these in his residence?
No. That is saying that any real or personal property they use can only be used if it is owned by the business. If it's not owned by the business, it can be leased, but only at fair market value and with the operator of the regulated business, but then they enter into side agreements where effectively the person who couldn't get approved is taking all the risk and making all the investments. So what this is saying is if you are renting someone
Well, you described it a lot easier than I could read this.
well, thank you.
Second question is on the area of compensation. And I'm assuming this is going along a similar line, but how can we regulate compensation? Why couldn't the employee in there be compensated by salary plus commissions of sales?
They can. They just need to be. They just need to get background clearance.
Why did I feel like it didn't allow for that?
Well, if you look on the fourth line,
No employee or agent,
unless the employer or agent has obtained the background clearance pursuant to this chapter.
But the one before that says may be compensated on any basis. No employee can be compensated on any basis other than hourly waged or fixed monthly salary. So for me, that says no commissions, no variable salary.
Right, but then the immediately following that is unless that employee has obtained background clearance.
Okay, so it's conditional there. So you could have
part
an
of the same
employee
sentence,
working
Victor.
hourly that doesn't have a background check?
Right now, we are set up, and this is something that can be changed, and we need to actually talk to the police chief about this. But right now, we are requiring a background check for managers and requiring that there be a manager on site anytime it is open. But we are only requiring for employees that the business run its own criminal record check, and we aren't requiring that they obtain an actual clearance from the police department.
Mark, is that the current ordinance or is that the new ordinance?
That is the new ordinance.
What does the old ordinance say in that regard?
I would have to look back. I don't recall. And also I'm confusing the old ordinance with
in the current. I believe it was everybody who worked there had to get live scan, which then we'd run the clearance through them. And I would prefer that it stays that way.
Okay.
So we currently have a two-step process. We have live scan that's done by our police department, and then we have a background check it's a little bit more of a deeper dive that's done by HDL. So there's a bit of a differentiation between the two, but we require of everybody.
currently, Matt, are both steps required of all employees, or is that second step that's a deep dive only required of the managers or owners?
Well, we haven't gotten to the level, I guess, of other employees yet, but everybody who applied in the first place was part of their package. We had them do the background check as well. So everybody who's part of their application package.
So we're not sure what the current ordinance says in that regard, if everyone's required to do the deep dive or not.
Well, the ordinance, well, let me get back to you on that if you want.
Sorry, Victor, thank you for your patience. Go ahead, Victor.
That's okay. So Mark, that what you just described to me is not clear in this compensation section to me. It looks like to me that you're going to limit somebody, they can work there, but you're going to limit their compensation until they get a background check. Seems to me they shouldn't be there unless they have a background check.
Mm-hmm. Yeah, well, I mean, it sounds like we are likely to switch to having all employees get a background check, with background check being both the live scan and the more detailed clearance. And in which case that section will no longer be actually necessary, because what it is doing is saying that if you are employed on a commission, then you need to have the background check, even though otherwise as an employee you wouldn't.
Yeah, that doesn't make any sense to me.
Okay.
I mean, it seems like the employer should have the responsibility to do the background check and keep it on record. And in the event that we need to intercede, we can go to those records and see that everybody's got a background check, or at least report that everybody's got a background check.
Okay. Well, that actually is something different than what I was hearing from other speakers, because it sounds like what you're in favor of is having the business do its own background checks of employees, so not have any City of Marina background checks of any employees. Whereas it sounds like other speakers were saying they wanted to have a City of Marina done check of all employees.
I don't have any trouble with that as long as the City of Marina is remunerated for that.
Yeah, we are allowed to do a fee for these checks.
I mean, we're not going to run around doing free checks, I hope.
No.
Okay. And then my last question is on page 12. And this is the section that talks about the operating manager's vacation time. And we're limiting his or her vacation time to 7 consecutive days, which seems unreasonable to me. It seems if somebody wants to take 2 weeks of vacation and the business can adequately cover that time that he or she is gone with another manager or an assistant manager, that would be acceptable. So why that limit?
Because if you look at subdivision B essentially says that if the operating manager is out more than 7 consecutive days, then you need to designate one of the assistants to be serving as the operating manager, which would be the person who the city would be contacting. So the rule is that you have to have an operating manager or a designated operating manager at all times with no more than a 7-day break. But then anytime the business is open, either the manager or an assistant needs to be present.
Yeah, I think every business needs to have an operating manager 24/7. I mean, that's responsible for what goes on there. So if somebody was gone for 7 days, then they don't have to be replaced by somebody of authority?
If someone is gone for 7 days, then the business would have to officially notify you of who is temporarily serving as operating manager. If they were gone for a few days, then then the operating manager would still be the official contact, but they would be required to actually have an assistant manager on site anytime they are open.
Okay.
Victor, can I ask a follow-up on that?
You most certainly may, Mr. Mayor.
Those 2 paragraphs, A and B, still seem mutually exclusive. B doesn't say anything to me about relaxing the 7-day restriction that's in paragraph A. So I think that paragraph A doesn't let me take 2 weeks, and paragraph B doesn't let me take 2 weeks either.
Well, the intent, and I could certainly clarify, was that if someone is on leave for more than 7 days, then you would need to have an assistant operating manager serve as operating manager. And it says that you would appoint somebody to serve as operating manager when the position is vacant or when the operating manager is on leave. But I can certainly clarify that language. I understand the concern.
Yeah,
If paragraph A said that leaves longer than 7 days must be substituted with an operating manager, that would be clearer.
Okay, I understand the concern, and I think I can easily come up with language that will meet it.
Mayor, this is Chief Nieto. The operating manager, there should be some wording that they too have had some kind of clearance. If you don't specify it, they could just say, I'm an operating manager.
Well, all operating managers and assistant operating managers are required to get background clearance and to actually be on the license.
Thank you.
Go ahead, Victor.
I'm all done, Mr. Mayor. It's back to you.
Thank you. All right, let's go to Nancy.
Okay. Thank you, Mr. Mayor. My questions go back to the upcoming election and a comment you made, Mark, that we could postpone doing this, take our time, and wait till another election. But my question would be, if we approved this with the ability of the council to go back and update it, wouldn't that make more sense to have a working document as of November than to have a document that we already know is flawed and then continue to work on it after the voters have approved our ability to do that?
I think it would. The issue would be that in order to put this on the ballot, we would need to have all of the rules that are going to be included in this initial ordinance nailed down. And if there is disagreement on some major part of the regulatory scheme, which folks want to resolve before it goes on the ballot, there may not be time to do that. But the approach that's taken by this document is to say, we've got a framework, we're going to put this framework on the November ballot. There will be a moratorium. Right now, it's just on the non-retail ones until July, to give the council an opportunity to come up with more detail, especially on the non-retail uses, and amend it further. And that approach would allow you to put this on the November ballot. I think doing refinements about all of the zoning rules and all of the rules that apply to each of the 7 types of businesses may be something that would be difficult to get a consensus on by early August.
Okay, thank you. My other question is regarding zoning restrictions.
Mm-hmm.
For instance, when the applicants came before the Planning Commission for the 3 that are currently approved, the original 5, there was concern about how close one of the applicants was to a couple of parks. There's a park across the street, and there's a park 2 lots further north. And our understanding was that parks couldn't be included as a zoning restriction. Is that allowed to be changed, since there was a lot of concern about it, so that in the future,
Yes.
Obviously this one's already been approved, so he's a non-conforming use, but in the future we could add those restrictions in under the ordinance?
Yeah, you have the council has the ability to amend its zoning code to put in almost any sort of non-arbitrary restriction. So if it wanted to have a zoning rule that a cannabis business cannot be located within X feet of any Y, it can write that in. My understanding is the problem with parks for this go round was the parks weren't mentioned in the existing ordinance as one of the things that you had to have a buffer against.
Okay. Yeah, I didn't understand what the problem was with the parks, but I certainly understood that there was a problem and we weren't allowed to forbid a business from accessing that lot because of proximity to parks.
Yeah, and my understanding, and Matt or Bob, but break in if I'm getting this wrong. My understanding is that the problem there was that there was no provision of the existing ordinance that prohibited or created a buffer around parks. And because it wasn't part of your zoning, that wasn't something that you could create on the fly as part of consideration of an applicant. Is that right, Bob?
Yes, I believe
Okay.
that.
And through the mayor, this is Christy Hopper. If I could
Sure. Go ahead.
join in. So the proximity to parks was located in Title 17 of the municipal code. So this was an amendment to the municipal code that related originally to alcohol licenses and in areas of undue concentration, and that is an ABC restriction, basically looking at areas of undue concentration that looks at proximity to parks. That's the only area, and that's something that we need to address with this ordinance, because this is something that the assistant city attorney came to me that we do need to address with this ordinance in looking at talking about these areas of undue concentration that cannot apply to cannabis because there is no standard for cannabis undue concentration. So that's where the parks came in. Does that make sense?
Yes.
Okay.
Okay. You also talked about non-conforming use. Our current applicants that were approved, should they open for business, they would be opening, some of them might be opening as a non-conforming use. Maybe only one or two would be non-conforming use. My question is, if that business were to fail, one that had a non-conforming use, and another cannabis business wanted to go into the same spot, because that was already approved under the old ordinance, could a new cannabis business go into the same spot, or do they have to open a business that would be conforming?
Well, it would follow the same rule as is for normal, non-cannabis, non-conforming uses. Off the top of my head, I don't recall what the rules are for transfer of a non-conforming location to a new business. Bob, do you know that one off the top of your head?
And Christy, do you know? I think.
Well, specific though to the cannabis businesses, they would have to go back through the entire process, starting at the competitive process currently. They'd have to compete. You wouldn't just get to fill in to a slot.
But I'm talking about under the new ordinance.
Right, but under the new ordinance, because we've split the regulatory side, which is about who can open it, with the zoning side, which is about what physically can be where. Under the new scheme, the rules that apply currently to non-conforming uses would also apply to a cannabis use.
Okay.
So,
thank you, Mr.
Commissioner.
That's correct.
Commissioner Amadeo, if I could help with something really quickly on the zoning. So in our current code, this is one of our constraints. The only place we can change anything by the city council is for permitted zones. And it's pretty specific within the ordinance. It says that you can change the specific permitted zones that cannabis is allowed in. And that's basically all we can change. So when it comes to things, that are more of, again, challenging, like wanting to add parks into the one category, that's hard written into the current cannabis ordinance that, the buffer zone, the 600-foot buffer zone is for schools providing instruction, kindergarten, blah, 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 and doesn't mention parks. So we would need to change it within the cannabis ordinance in order for you to have the parks buffer in there as well.
I
The way
understand.
it's currently set up.
Yeah, no,
Okay.
I understood that
Okay.
the current ordinance would have to change to the new ordinance in order to do the parks.
Right, but just to be clear, there's no rule in state law that says the parks can't be included in that list. It's just that at the moment they aren't.
And just for clarification, the current ordinance as adopted by the voters, because of the language that is in the ordinance or in the initiative, there's a current prohibition of alcohol serving establishments within 600 feet of a park, which would eliminate any alcohol serving establishment, including beer and wine at a restaurant and that type of thing, within our almost our entire downtown area. So that's something that we really need to think about. So if we want restaurants to come in, right now the current ordinance would prohibit any new alcohol licenses within our downtown.
Now, Christy, do you mean the cannabis ordinance has an effect on alcohol or the existing?
Yeah, and Bob can weigh in on this. It's because of the language that was in the initiative that changed the general zoning regulations in Title 17. The city is unable to change that to take out alcohol serving establishments to allow them within that buffer area. And Bob, can you elaborate a little bit more on that?
I'll try. This is we're talking about in Title 17.
Title 17, it's the general zoning regulations
Right.
on use regulations.
Right. I think that's correct. That the buffer to parks only applies to alcohol and not to cannabis, as we discussed. And I haven't looked at whether the effect of this on the downtown, particularly in that case. So I'd have to kind of defer to adding any more. Maybe.
I think these are details we can definitely get into after tonight. Yeah, because I think hammering it down that low tonight is a little tough. We just want to know the big policy. Do we want to kind of make sure that we don't have that same situation, and then we'll work on that.
Okay, so I just want to confirm that the cannabis ordinance has affected alcohol and restricted the ability for restaurants and other alcohol carrying businesses beyond what they were allowed to do before the cannabis ordinance?
That's correct, because parks were added into the general zoning regulations, so general use regulations in Title 17.
Now, is there a Title 17 component to the existing ordinance? I'm looking at it. I just see.
Yeah.
I see I see section 19s, a lot of 19.02, 19.02. I don't see 17s.
So Mr. Mayor, in your staff report packet, if
You're muted, Matt.
So in your staff report packet, if you look at the ordinance that was included under A, which is the existing ordinance, go to page 24 of that document. And about halfway down, you'll see 6, and it's section 1706.020 A and B. And this is the sections that were amended in the zoning code per the voter initiative.
In my page 24, it doesn't have it. My page 24 says 19.10 appeals process.
So 24 of the actual ordinance document, not the pagination of the whole staff report packet.
Okay, I see section 6. Go ahead.
Yeah. So section 6A, B there are what were changed in the ordinance that affected alcohol. So this currently just talked about permitting alcohol at these establishments. And then if you had to do a finding of public convenience and necessity, here were the requirements. We put in now cannabis into this, which has caused a little bit of a snafu because it almost requires a finding of public convenience and necessity, but there's no definition of what an undue concentration is. There's no real parameters to go around that. And it also now puts parks in the prohibition for establishments that can get an alcohol public convenience and necessity finding if they're within 600 feet of a park. Did I say that
Okay,
correctly?
so I see that as a flaw. If you were to delete the words or alcoholic beverages, does it remove the problem caused?
I think the biggest problem is just putting cannabis into this section. It would have been probably better served if you tried to accomplish the same thing with it being its own section.
I agree with that. Cannabis needs to be an additional section outside of alcohol, because there is no clause. There's nothing in state law that talks about undue concentration of cannabis establishments. Is an in the ABC Act under Business and Professions Code. There is a clause about undue concentration and how we address that. And that's what the city of Marina has adopted under that particular section of Title 17.
And this is
alcohol.
So, and I know, Bob, you're about to jump on, but I also agree. The ABC laws got changed from the bigger cities, that the economically impoverished areas, they were putting alcohol or liquor stores everywhere, bottom line, in bars. And so that's how the case law came about and the legislative changes. We really don't have enough data about marijuana yet to make any of those decisions, nor am I aware of any case law right now that is showing any, prohibitions on concentration, and with any numbers, with any data behind it.
What we would probably want to do is have the new ordinance revert this section back to the way it was before. Ordinance revert this section back to the way it was before the old ordinance. So have it just be about alcohol. And then if we want to have buffer zones for cannabis, have that be a separate zoning provision, which is just about cannabis and doesn't make reference to terms like undue concentration. They're coming from the ABC laws, because our ability to zone cannabis is, we have quite a bit more authority there than we do with respect to alcohol. With respect to alcohol, there are state law limitations on what we're allowed to do, because the state has the ABC, which is the main regulator of alcohol. Whereas for cannabis, the main state cannabis law explicitly reserves to us all of our zoning authority that we would have with respect to any other business, meaning that we are able to make rules for it just like we would for anything else. And we don't have to refer to things like undue concentration or special state rules that have been created for alcohol.
And we don't have the ability at this point in time to make that change.
Correct. Yeah, no, we are, this is kind of a first look thing for me, but we are locked into this provision because it was voter approved in a ballot measure and the ballot measure didn't specifically say that the council can make amendments.
So if at a high level tonight, we just directed staff to fix the alcohol problem, then you would come back with one or more fixes.
I feel like you've given I've heard enough direction and enough consensus to be able to draft this change. Do the staff members have any questions?
Oh, and I think it's an easy fix to remove cannabis completely from Title 17.
Okay, but I think at a high level, that's one thing I'm hearing, and we'll probably build a motion that has that included in it so that it's clear and we have a vote on it. Nancy, please continue, and thanks for letting us jump in.
No, thank you. I didn't have any other questions.
All right. David Burnett. Good evening, David.
Good evening, Mr. Mayor and Council. Just a quick question. Maybe this will muddy the water. I'm not sure. But a couple of years ago, the MPUSD school district tried to map out what they called safe routes to school provision. And I'm just wondering if the council would entertain a wording that if and when safe routes gets enacted, that be incorporated into this ordinance. I think the visibility of folks coming and going for school children might be an issue. And my second question, I don't expect an answer tonight, but if you guys could consider it, I'd appreciate it. The second question has to do, and I know this won't be answered tonight, and I apologize for opening a can of worms, but I want to ask the city attorney if the approved districting that was enacted last year would enable or could somehow be used to have a cannabis-free district. In other words, would a zoning be held in a particular election district to be invalid, or would districts be able to opt in and opt out of cannabis ordinances?
In my opinion, without doing any research, David, I don't believe that would be appropriate. I mean, the cannabis ordinance could apply to the whole city.
Yes, I understand that, but in the future, would there be an opportunity for a district to say, well, we don't want cannabis in our district?
Your city, unlike some larger, older cities, doesn't have any kind of sub-citywide government. So in general, any regulations need to be adopted by the council. They don't necessarily need to be on a citywide basis. The council is allowed to zone different parts of the city differently, but there's no ability to have a vote just by the people or representatives of a geographic area of the city for the rules that apply to just that geographic area.
Okay, well, we recently adopted and approved a districting ordinance for the city. So there are, in effect, political areas now within the city.
Correct me if I'm wrong, Mr. Athy, but I believe that what's been done is that the city has adopted council districts, so each council member is elected by the voters of that district.
That is correct.
But that's different from creating a district government separate for each district. It's just each district elects a representative to the citywide council.
Yes, you understand that. Yeah.
Right. Some very large cities, like say Los Angeles, have devolved some sorts of decisions to neighborhood councils that represent just one part of the city. But that's not something that Marina has done. And that's not something, to my knowledge, that has ever been done in a city as small as Marina.
So I guess, David, the answer would be, right now it doesn't look like it, but we would have to do more research.
Thank you.
And would it be any difference on cannabis as it would be for alcohol businesses or restaurants or any other type of business sector?
No.
No.
This is a more fundamental issue, which is that you have one government for the entire city. So there isn't a mechanism for self-governance by a portion of the city.
Right. So my question is whether the answer is yes or no to being able to district eliminate cannabis. Would that same yes or no answer, whatever is the correct answer, apply to any other business sector?
Yes. This isn't a special cannabis rule. This would apply to any sort of zoning.
Okay, David, please continue.
That was primarily my question. I did, thanks for Councilman O'Connell clearing up the process that we're actually going to repeal the current ordinance and adopt the new ordinance if approved by the voters. So I just wanted to make sure that was my understanding too.
Thanks. I think as a team, we're about to engage in that activity. But yes, thank you to Frank O'Connell for leading the process to get here. Okay, Brian.
Thank you, Mr. Mayor. Thanks for the presentation, Mr. Mandel. I have about 4 or 5 points I'll try to get through really quickly. And they mostly deal with things that have been left out of this new ordinance, understanding that there must be opportunities for the council to kind of rethink how the implementation will look like. So the first one deals with odor. The old ordinance has a simple statement that says no odor shall be detected by sight or smell outside the permitted facility. I guess my question is, do you believe that if we were to re-implement that language, it would be enforceable or legal? Or
I think it would. The more specific you are, the easier it would be to enforce something like that. It is certainly a reasonable thing to try to include.
Okay. And I'll just make a note that I think that that issue becomes almost moot if we decide to prohibit the unlimited other uses, or at least put a moratorium on those, but that's maybe more of an opinion. Also, the issue of signs was left out, and so the old ordinance talks about no signs. I think it says describing cannabis shall be allowed. And I'm curious, same question with that. Is that something that you think we can implement in the new one if the council chose?
I think we could.
Okay. And then the 2 other items, one is hours. I noticed that wasn't mentioned, so not really a question, but I'm assuming there's an opportunity there to rethink whether the hours in the old ordinance are sufficient for the new ordinance. And then lastly, in reviewing some other cannabis ordinances, I noticed that a lot of them amplified the language in Prop 64, things like smoking in public being illegal and the fines associated with those. Is that something, is that maybe a best practice, or is something maybe you think would be appropriate to do in a new ordinance, or is that better left as something separate?
I prefer to not duplicate the state law in your local law for a few reasons. First of all, it makes the local law longer. Second of all, the state laws, and especially the state regulations, they're adopted by the Bureau of Cannabis Control under the state laws, are constantly changing. And so it's better, I think, to just defer to the state rule unless there's some specific special rule that you want to have for City of Marina. Because otherwise there becomes a question of, okay, why is this state rule included, but this state rule not included? If the Marina rule is similar to, but not exactly the same as the current state rule, what does that mean? We do have a provision in here which says that any violation for any sort of violation of the state rule.
Okay, thank you. I'll slip one more question in for the police chief, if I may, and that is, in Marina, are we aware of anyone that's actually been fined under the rules in Prop 64 for using marijuana in public, or is that not something that's happened here?
Nope, I've been here for 2.5 years, and I would have to, well, let me take that back. I'd have to do a run to see if we have cited anybody for that, but I'm not aware of it.
Thank you, Chief. Thank you, Mr. Mayor.
Thanks, Brian. All right, Councilmember O'Connell and then Councilmember Berkeley.
Thank you. Mark, is my understanding correct that if we were to take the new ordinance and delete from it cultivation and manufacturing, that at a later time, the council could put that into the new ordinance without going back to the voters?
It could, unless there were a provision in the new ordinance that was presented to the voters that said that it couldn't.
Okay.
So if you present this ordinance that I've prepared with a section that says cultivation shall not be allowed, then the council would be able to allow cultivation later. if you add a provision that says cultivation shall not be allowed, and then in the amendment section, which says this may be amended by council, say, however, the prohibition on cultivation may not be amended without a vote of the people, then the council can't change that prohibition.
In the applications that the council heard a couple of weeks ago, one of the owners of the property that was under consideration, he wasn't running the business itself, but he brought up the question of federal law and the banks. And the question was basically loan process. But in the past, I've heard that there's a great deal of difficulty with banks accepting funds that have been raised by cannabis businesses since they're worried about the existing federal law. Do you know if there's any lessening of that burden or that problem?
My understanding is that that's an ongoing problem. My understanding is that the federal government essentially pressured financial institutions to stop taking accounts for cannabis businesses, both because they are illegal under federal law and also because they were perceived as being a money laundering issue. So what has happened is it is very difficult, my understanding is, for cannabis businesses to obtain any sort of bank accounts, which has the unfortunate knock-on effect of meaning that these businesses tend to operate as cash businesses, which unfortunately makes them even more susceptible to money laundering problems, and also makes it difficult to audit things like their gross receipts for tax purposes. But the direct answer to your question is, my understanding is that it is difficult to impossible for these businesses to get a normal bank account.
And potentially robberies, because people are aware that it's a cash transaction and they're having difficulty depositing it. I mean, that's a risk that I think is evident under all circumstances, but when they know they cannot just take it to the bank and deposit it in the bank,
Right.
it's got to be deposited somewhere.
Yeah, I defer to your police chief on that, but my expectation would be that robbers know that there's a lot of cash on these businesses. My expectation would also be that the owners know that the robbers know that, so they have fairly extensive systems of vaults to keep their cash. And also, they tend to have pretty elaborate security systems and an on-site guard. So I don't know how pervasive the problem is of these businesses getting robbed, but I defer to your police chief about that.
Councilman O'Connell, that's
Sure.
they are a target for people who like to commit robberies. That is why the cannabis locations have to have security plans, which are not required for most businesses, to deter people wanting to rob those locations.
Thank you. Mark,
Councilman, I was just going to mention that I think what part of the concern about the federal restrictions also went to the fact that apparently there could be some issues with federally backed mortgages for landlords who rent to cannabis businesses. I think that was brought up at the previous hearing.
Mark or anyone else, my concern is the potential problems that the city may have relating to cannabis licenses and permits. What do you recommend as far as either insurance being required or indemnification being required to protect the city's interests? I know the individual council members wouldn't have so much a problem, and even if a litigation is just frivolous, it's still litigation that we would have to fight. So what suggestions would you have as far as either the amount of coverage through insurance of some sort or indemnification? But then again, realizing indemnification by the cannabis owner isn't going to do the city a heck of a lot of good if the company walks away. Any thoughts on how to protect the city as much as possible in that area?
I don't have any immediate thoughts on that. My guess would be that it would be very difficult for a business that operates in the manner that these are forced to get insurance, and an indemnification from this sort of cash business isn't particularly useful necessarily.
Is that what the paper's not written on?
Yeah, and then there are also issues with, since you're approaching this as a regulator, not as a proprietor, there are potential issues with requiring someone to indemnify you as a result of issuing a permit.
Thank you.
So,
I don't know
Councilmember
anything-
O'Connell, if I could, I was just
sorry.
going to add a little bit to that, and that's in the process that we set up currently with HDL. They provided us templates and everything of indemnification agreements and insurance requirements that we did have every applicant sign off on, and that includes every person within the applicant package, if you will. So, so we tried to protect for that regardless, as we had them agree to it.
Thank you.
All right, thank you, Frank. Councilmember Berkeley?
I'm going back just to something to be sure that I'm understanding it clearly. So as I understand it, the permit goes with the land. Is that correct?
Essentially,
Not with the land, with the store. Go ahead.
the permit is issued to the business and with respect to operations on a specific location. Owners can be shifted in and out. And if the business were to move, it would need to do an entirely new application for the new location, but it would essentially be able to transfer its slot amongst the 3 slots.
Okay. And so if there is a business that has agreed to do a lot of work for the city, for example, around sidewalk work or such things as that, and they start their process, but their year term expires and they're still not operational, does the permit then automatically renew itself, assuming the criteria and security is still the same?
There are provisions in the ordinance I drafted about how long one gets to hold on to a slot. And actually, it's in the renewal section. Yeah, it's section 5.80.130E. And this is something that can be changed if the council wants. And it says that basically you can only renew if the business has been open to customers for at least 6 hours per day on no less than 80 of the 180 days prior to the renewal date.
And so basically, oh wait, hold on. I'm just reading through it again. Can you, it's 580.130E. Hold on. Master their business has been open. Okay. All right. So if they do not meet that criteria, the city has the capacity to say, we would like to revoke your license, or not revoke it, but we can choose to not renew it.
Yeah, it's not a matter of revoking. It's a matter of the business would not have met the criteria for renewing. So the permit wouldn't renew. And then 2 months after that, the slot would be opened up.
Mm-hmm. And is it thoroughly at the city's jurisdiction to determine how that works? So for example, if a business is in process of doing renovations and they still have not completed it within that year, and they come to renew their application, and can the city, and they say, well, we got held up because of planning department or something like that, can we still say we don't want you to continue? And not
basically the default is that they need to have met that 80 of the 180 days requirement, but the administrator can waive the requirement in the event that extenuating circumstances such as a public health emergency, the destruction of the business premises, or enforcement of administrative proceedings by the city under this code make it impracticable for the commercial cannabis business to be open to customers as would otherwise be required by this section. We could certainly expand the conditions under which the administrator could waive that requirement. We would need to have specific conditions where it can be waived. So it can't just be left to the unfettered discretion of the administrator.
Okay. And then similarly, if and we touched on this a little bit earlier, but if we wanted to not have 3 dispensaries, what if we wanted to cap it at 2? How would we go about doing that?
You could, well, you could either have that changed in this ordinance before it's submitted to the voters, or the council could amend this ordinance to reduce or expand the number. Anyone who has a permit would be grandfathered. So you wouldn't, if there were 3 permits, you couldn't then reduce it to 2 and say, okay, one of you 3 has to give up your permit.
Right.
But what would happen is the first time one of those businesses close is, instead of having a replacement 3rd permit given to somebody else, you would now just have 2 businesses. Then when one of those closes, then you'd have a permit slot open up.
And if one of the 3 that currently has it decided they wanted to close, would they be able to then, as with this new ordinance that we're proposing as it stands now, would they be able to then sell the permit to another business to come in so it would stay at 3?
Well, under this ordinance, they would be able to sell their business as long as the person who's buying it is passes the clearance. And then that person would be able to operate the business at the existing location and would be able to put in an application for a new location and could switch the permit from the existing location to the new location. We would have to think about how that applies with respect to your grandfathered permits. But my assumption is the cleanest way is that we'd want to give your 3 existing permit holders the same rights under this as a new permit holder would have.
Bob, were you going to say something?
I was going to say that was essentially the way any business is treated now.
Okay. I think that answers my questions for the moment. Thank you.
Okay, and we're gonna go to folks that haven't spoken yet. Mayor Pro Tem Morton, and then we'll go back for a second round.
So I just wanted to follow up on, can you hear?
Yes.
Yes.
Okay. I wanted to follow up on a couple things that you pointed out, Mark. One is that in section 5.80140, change of owner or operating manager. So how it's written in the draft here is that they freely can change in and out owner manager, provided the only criteria is the background check, life scan, and the background check.
Correct.
So having just gone through this process with the applicants, there was a tremendous interest in the questions being asked and in the applications about owners, operators, being Marina residents, being people vested in our community. So when we're seeing large tobacco companies also looking at cannabis as a new income stream, I'm not sure we as a city would be all that happy with some large national tobacco company coming in and getting one of these licenses without the city council being able to say yes or no. So the way this is written, it appears that new owner, city has no control if those 2 criteria of background checks are met. So if in fact we wanted to make sure that council could say, you know, we want to keep this as a local industry or regional or something other than the licensee is saying, "Go, I'm going to sell out because somebody's offering me $1 bazillion," and we lose the character of what we approved when we issued the license. How would you fix that?
Well, the new ordinance treats cannabis businesses like it would treat any other business in the city,
Right.
which is to say that the city is interested in in regulating what the location looks like, how it operates, ensuring location operates according to law, but doesn't have an interest in who is owning the business, with the proviso that we do, like you would for a taxi driver or any other closely regulated business, you do want to ensure that the person doesn't have a criminal background. It would be unusual for a city, with respect to businesses located within the city, as opposed to with respect to its own contractors, to be trying to pick and choose amongst people who would like to open a business, which of those people is their preferred person to open the business. I think it would, if the city wants to go down that route, we would need to do some more research on the extent to which that would be legally possible. But also, one of the kind of premises of this revision was to remove the competition between individual applicants to try and make themselves most personally impressive to the council. A big reason for doing that is that it can be difficult for a council to make good findings for how it's having a rational basis for deciding between people, which is why we've kind of switched to something that doesn't have those sorts of judgment decisions and instead has a lottery and then kind of a pass-fail test in terms of, do you have a criminal background or not?
Okay, great, because that's exactly what you just described was what. Okay, great, because that's exactly what you just described was what we just went through last week. Was we were being sold by individuals of why I personally are meritorious. In other words, I live in the city of Marina, I'm going to hire people. So you've taken that out of this by putting in this provision. The other question that I had is, if there's a lottery available, a license available, and you're going through the lottery system, how many, and maybe I just didn't see it in here, how many applicants are chosen? Is it a ratio to how many licenses are available? But 3 to 1. If you have one license available, what's the lottery? How many you're pulling from that lottery?
If you have one slot, you would pull one name from the lottery. Then that person would have the opportunity to go through the process of getting their site permissions, going through the planning process, and getting the regulatory things done. That is intentional because the process of obtaining a site is complicated and expensive, and it's problematic to require multiple people to lock down a site to make a proposal when they don't know that if they follow all the rules, they'll definitely be able to get the permit. Because they don't necessarily own the site, so they're having to enter into some sort of option agreement with the landlord and tie up the site without using it until the regulatory process ends. And then if you have 3 people who go through all that, it takes 6 months, only one of them gets the permit. The other 2 and their landlord have just spent a huge amount of money and huge opportunity costs to go through that.
Yes, and we just got letters all about that. So it's great to hear that these issues that we just had happen a week ago are being cured. Thank you.
Thank you.
Okay, I had a few questions. Regarding parks, Mark, well, I'm sorry, not Mark, but Christy and Matt, is there a restriction on the proximity allowed between alcohol businesses and parks in Marina?
Well, previous to the initiative, no, there was not.
Okay. If we were to fix the problem caused by cannabis, would there be any restriction on the distance between alcohol businesses and parks?
Not if we revert back to the previous ordinance language prior to the.
Okay. The risk has been brought up: financial risk, federal government risk, lawsuit risk related to cannabis, risk to the city. Is staff aware of any risk that has manifested in other cities, Delray Oaks, Seaside, Carmel Valley, Salinas, San Jose, Watsonville? I see conceptually there's a risk, but I'm asking if there has been a demonstrated risk to your knowledge.
Are you talking about in relation to parks?
No, I'm talking about in relation to liability to the city getting sued because of something that's cannabis related.
I'll defer to the attorneys on that one.
Mr. Mayor, I'm not aware of any. I have to say that. I'm not looked deeply at it, but no, I'm not aware of any.
All right. Is smoking cannabis in public illegal now?
I believe that is illegal under state law.
Yeah, I believe it is too.
I believe.
Yeah.
So does,
in public it is, yes.
Yeah.
Correct.
all right. So if I'm walking down the street or I'm in a park or if I'm in a shopping center, parking lot, can I smoke legally or can ingest cannabis legally?
No.
All right. Does the ordinance that we have now speak to that issue or just defer to state law, which prohibits it?
That's a state law provision. So yeah, our ordinance does not address that.
Doesn't address it because it probably is already illegal. Okay. Is there a problem with the current way that odor is prohibited from cannabis businesses? Is it too lax? Is it too confusing? Too hard to enforce?
So I think in our current ordinance, there isn't a provision at all that I believe addresses odors, other than saying you can't have negative impacts on your surrounding neighbors.
Okay,
So,
I thought recently when the conditional use permit near Paul Davis Drive, Marina Greens came up, it was in the conditional use permit that there'd be no odor smellable outside, detectable outside the business.
As a condition of approval.
In the existing ordinance, it applies to dispensaries only. Under all of the other types of cannabis uses, there's no mention of odor. And so as a condition of approval for the cannabis growing operation, we did add that odor condition. So this is something that can be corrected in the ordinance, and Mark, I will defer to you on that.
Yeah, no, we can create any rules we'd like about odors in either the cannabis ordinance we put before the voters or an amendment to it that's adopted later by the council. The rule in the current ordinance is in 19.02.100H, which reads, no cannabis or cannabis odors shall be detectable by sight or smell outside of a permitted facility.
That's in the current ordinance?
In the current ordinance.
Yeah. Does a facility?
I think that is unclear in the current language.
I believe it only applies to dispensaries.
That's correct. It's only under the provisions for dispensaries.
Okay. How late can liquor stores or restaurants in Marina sell alcohol?
2 a.m., I believe.
And how early can they sell alcohol?
I believe it's 6 a.m.
6 a.m. to 2 a.m.
I believe
So there's
so.
a 4-hour break. What does the ordinance say currently about cannabis business operating
So
hours?
It's
I
9
think-
a.m. to 11:59 p.m.
Correct.
That's these sorts of provisions are in 19.02.100 of the existing ordinance, and we can transfer these sorts of provisions into the zoning rules or into the safety and security or operational rules. But right now, they are not in the framework that I've prepared for today's meeting.
Does
Okay.
state law set, like state law sets the hours for liquor? I know, but does state law also set hours for cannabis? I don't know.
I think it does. I would need to look that
I
up.
suspect it does too.
All right.
I believe that's correct.
All right. So just to confirm that currently the current cannabis ordinance is more restrictive on hours of operation than our laws that apply to alcohol.
Yes.
Okay. Tina Nieto, are you aware of cannabis in other cities? Have you heard from other police chiefs that they have a problem with cannabis park proximity distances?
Cannabis to parks?
Correct. We had some discussion tonight about allowable distance.
I heard about the parks. No, actually, there hasn't been complaints in the chiefs meeting, Monterey County chiefs or the Peninsula chiefs
All right.
regarding cannabis.
Would it be difficult for you to confirm if it's a problem that hasn't been talked about, or if it's not a problem and that's why it's not been talked about amongst the Monterey County chiefs?
I could confirm it through our own CAD system for the Peninsula area, minus not Delray Oaks, but Carmel. But I don't believe Carmel has cannabis. So.
Okay. And getting to the discussion about moratoria on other cannabis businesses, Mark, can you repeat what you think would be the primary justification for a moratorium on non-dispensary cannabis businesses in Marina?
Basically, it would give the council an opportunity to create a set of zoning rules for them, because it would be difficult, I think, for us to generate a complete set for all 5 or 6 uses within the next month, unless what we do is just copy what is in the existing ordinance.
So is there a problem caused by the way the existing ordinance zones non-dispensary cannabis businesses?
I honestly don't know.
So, Mr. Mayor, we do have two, I believe, still pending applications for those type of uses, and those would still be processed under the current ordinance.
So my question is, why are we trying to fix something if we're not aware that the current arrangement is a problem?
I think I'm remembering what Mark had pointed out a few minutes ago, was that the reason of putting the moratorium on currently was to allow us to have time to think through it and to amend our ordinance as we wanted to, that the council wanted to have all the right pieces in place instead of rushing it right now, because it was just a lot to take on. So ultimately, you could take the same framework that you have in this ordinance and apply it forward. And speaking with Mark, it made a lot of sense that when it comes to manufacturing, just cultivation, those type of uses, it does make a lot more sense for it to be a use permit, because you're going to have a lot more impacts. So perhaps you do have 2 tracks ultimately, and you can create that system that you are ultimately happy with.
So following up on that, if you had testing or manufacturing, what increase in impacts do you have above the impacts associated with dispensaries?
I think it comes down to the processing. You know, they use certain chemicals for manufacturing. You've also got the odor issues then as well.
With
there's
testing,
waste.
you have odors with testing and manufacturing problems?
I would imagine you do, because you have a high concentration of the product and you're trying to extract oils out of it and different things. So they use chemicals, they use, you know, a little bit more processes than that. And I'm not an expert at it, but I just using somewhat of a, you know, thinking through the fact that they're doing this process, it's going to be more of an industrial type activity that's happening.
Because I copied this from Seaside, I assumed that their legal staff and their city council wouldn't want to do something that was contrary to industry standard and cause problems. But I might have been wrong in assuming that. So I want to ask now, how difficult would it be to confirm if testing and manufacturing actually, because they're all over the state, it's nothing new, that they actually have impacts beyond dispensaries that would require us to spend time on trying to fix the additional impacts that they cause? How difficult would it be to ascertain if it's true or false that they have, you know, real impacts beyond dispensaries, such as odors or chemical hazardous materials, et cetera?
So if I may, Mr. Mayor, I think that the city of Seaside is dealing with potentially six dispensaries. We hired a consultant to kind of help us out with the staff reports and that type of thing for us, but he's also been working with the city of Salinas with all of their dispensary applications, as well as cultivation, manufacture, and that type of thing. I think that's a good question for him. Kelly Miller, he works for Rincon Consultants, to see maybe what the challenges he's had in the city of Salinas, because I think that's a good test that we may be able to get.
So talking to the mayors of Salinas and Delray Oaks, they are giddy about the non-dispensary businesses coming to their city, that they're making a lot of money on testing and manufacturing, and they act like they can't get enough. And they talk about the revenues that they generate for their city. I didn't ask them if it caused any problem, but I think it would be rather easy to talk to our sister cities and find out if they could do it over again. Since they have testing businesses, they have manufacturing businesses, they're not in the process, they're beyond that. They have revenue generating testing, manufacturing. So it seems like it would be easy. And I'm asking you, would you be able to, between this meeting and the next meeting, confirm whether or not we need to take the time to fix problems that may be associated with testing and manufacturing?
I'm muted. So seeing as we don't have a lot of areas where we can do testing and manufacturing, unless we change the ordinance to allow more, I mean, we could reach out to, I'm thinking Salinas, Greenfield, Matt, can you give any more? Delray Oaks, I'm not sure if they're doing manufacturing there. I think they're just dispensary. I can't remember.
No, they have non-dispensary businesses, testing, and I believe manufacturing, but for sure testing.
They do. We can check with Seaside as well and see what's going on over there.
Okay, the reason I'm asking
Mr. Mayor.
Go ahead, Matt.
I was going to say, if the preference is to leave these current provisions, I don't see a huge downside in that, to be honest with you. This is not a competitive process when it comes to dispensaries and everything else. They come in, they submit an application, and they get vetted just like we do with the other applications, but we just want to make sure that they're a quality business, they know what they're doing. And then the planning commission awards those permits. They don't go on to the city council. And we can award as many as we want. There's no cap. So if your desire is to take these rules and drop them into the new ordinance, I don't think that's an issue. Mark, do you?
You're muted, Mark.
Yeah. Legally, I don't think there's a problem dropping in the rules. The only issue would be whether the existing rules have the policies that are desired. And that's not something that I can address.
All right. Well, the reason I'm asking these questions is because I thought the whole purpose we came here was to fix the mistakes, not to reevaluate based on all of our values, every part of it, potentially making it more restrictive just because some of us have concerns that aren't covered by the current one. But anyway, that's later on for comment. Okay, let's go to Kathy, Nancy, and then Frank, Commissioner Viola, Madeo, and Councilmember O'Connell.
Okay, so I'm on then?
Yeah.
Okay, great. Okay, so I like the whole discussion about the competitive system that we had actually endured this last go around versus a regulatory process. And it sounds like, I know there was mentioned before during our previous process about using a lottery system, and we were told by Mr. Rathie that we could not do that, but I understand it was way into the process already of considering the applications. But now we could do a lottery system that would essentially, and we could put a limit of, let's say, 5 applications to be determined by a lottery. And so then they enter the system and they go through a regulatory process, and anyone who basically, is compliant with those really has already been determined that they are in. And Mark, at one point you said in the presentation about permit limits, and I just wanted to ask you, were you kind of suggesting that we treat cannabis like all other businesses, and that we shouldn't have a limit on the number?
I think that the smoothest way to do this sort of regulation is to not set a limit on the number. The reason being that if you don't set a limit on the number, then people will come to you, will want to start a business. They will figure out a location. They will come to you and get the regulatory clearance. So get the clearance on their on their background check. They will come through your planning counter and the planning commission if necessary to figure out what they need to do to develop their location if their site is appropriate. They will come to your police chief with their plan about safety and security, develop a plan, and then get that approved. And then if they can get through each of those hurdles and can come up with a plan that meets all the requirements, they can open. Having the limit on the number of businesses means that we can only open the gate for someone to enter that process each time a slot opens up. And we have to basically, if we have 3 people who want the slot, we either do what this ordinance says, which is we have a lottery amongst the 3, let one person go through, see if they can come through the hurdles. And then if they can't, we need to go back to square one, let another person through.
Right.
Or do the competitive process, which for reasons you've seen doesn't work all that well.
But
but if you have no limit, what will happen is you'll have all 3 people, they will just go through the process. Maybe only 2 of them will actually wind up being able to come up with a plan and a location and financing and stuff to actually have their business get all the permits. 1 or 2 of them, once you've gotten those 2 people through the thing, 1 or 2 of them will wind up actually opening. And then who knows how many of them, once they open, will actually stay in business. So I think that if you don't have a numerical limit, you're unlikely to be awash in cannabis businesses. You might have more than 3, but you might have 4 or 5, but how much of an additional impact does having 4 rather than 3 really make? And the experience in a lot of cities, like City of Los Angeles, is that these businesses are constantly going out of business, opening, and such. So if you set a numerical limit, you're going to be constantly having to do lotteries, constantly having less than the limit actually open because the slots, things have gone out of business and the slots are waiting being filled. It just winds up being a burden on your staff. It also winds up being a burden on the applicants because it's really hard to hold off on a business plan until you happen to win a lottery. And it's even harder to create a business plan and secure a site when you don't know that even if you get through all the process, you'll be able to open because you have this competitive thing like you've had now. So, to me, and this is somewhat me expressing a policy choice, which is something I try not to do. To me, it makes sense to not have a limit. I think where cities have gotten into trouble with not having limits is where they don't have limits, but also don't have a rule and don't have strict regulations, because which was happening a lot back before these businesses were legalized for adult cannabis, back when there was only the medicinal. So what was happening was you were having a lot of fly-by-night folks show up and open without having very many regulations apply to them. And that creates problems because you don't know who these folks are and you haven't approved an operating plan. But if you have good regulation, it's not clear to me why the risk of potentially having 5 of these businesses for a while is really a problem as compared to 3.
Hey, Mark, this is Chief Nieto, and I came from the city of Los Angeles. So I'm not making, it's up to the council and to the planning. But one of the problems you would get is that even though they open and close, you would get concentrations within the legal limits, and they would be concentrated in areas that the rent was cheaper, which then would impact economically impoverished neighborhoods a little bit more. So I did see it as a small policing problem. Again, I'm not trying to decide policy, but I came from that city and had to deal with that.
Thank you, Mark, because I think that, from where we all came from in this last go around, that would, I understand your logic, but it would also at the same time be sort of seen as risky, being that we started off with wanting limits. Mm-hmm. I understand your point, and I just wanted to make sure I understood it. So, a lottery with a limit seems more like what was conceptualized for us. And if we did your recommendation, I understand all of the reasons for it. And it makes sense also because, on the Planning Commission, that's what we do. We don't say, we only want a certain amount of some kind of development, in this section or whatever. It's really who is out there who can have the resources to get through the gauntlet, so to speak. Mm-hmm. So we don't put any limits, but I'm not saying that I understand yet where I fall on this, but it's a big decision, a fundamental decision, and a perspective that I think we all have to really seriously consider. But thank you very much for clarifying that.
And just to clarify for everybody on the call, the ordinance that you have before you does have limits and a lottery. Yes. It doesn't have the unlimited. That was just something I kind of put into the presentation as a thought piece.
Yes, totally understand.
And we carried through the limits that were approved by the voters in 2018, the same level.
Yes. Okay. Now, on page 3, number D says, to minimize social harms which may arise from cannabis, including youth consumption or intoxicated driving. And this whole issue of youth, I have spoken about this for at least 2 years before the council and other forums, and that's always been kind of a real concern for me because I see what's happened on the vaping and some of the fallout in terms of our youth, despite all of the parameters for restricting vaping to youth, and I'm just concerned about this. So in looking at where D is reflected in this policy, I can only find reassertions of of the age limit, and that's pretty much it. And I'm wondering if on page 22, number 1B, we talk about local enterprise and community benefits. we have all of these point system for all kinds of things. We have, you know, we get, let's see, a maximum of 8 points with 1 point for every city and marina resident that a business commits to employ, and 1 point for every specified annual substantial commitment to the applicant's choice to any nonprofit or business within the community. My question is, and maybe this is Mr. Raffi, can we build more into that in this go around? Because maybe that's the appropriate place for, you get additional points for locations that do not displace existing businesses, or additional points for substantial commitment to youth drug education, for example, using current medical findings or whatever, however we want to add in some more of that. Is that possible in that section?
Well, the concept of points is something that doesn't exist in the new ordinance. That's concept from the old ordinance. Because when you have points, that's really for a competitive system.
Oh, okay.
You can move requirements into this law, either as operating requirements or safety and security requirements, or as part of your zoning regulations. One thing I would recommend against is encouraging the businesses to spend money on community projects. I think a better approach than having them spend money on community projects or make donations or do education campaigns is to increase the tax that you levy on them, raise money for the city to do it, because that way you have, the city has more control over what is distributed in terms of information. You won't have a situation where a applicant is using a donation as a way to influence an elected official. And also, just in general, I think it's hard to trust the operators of cannabis businesses to put out good anti-youth marijuana materials. I think it winds up being things that at the very least wind up kind of being advertisements for the businesses, and can become the kind of things which look like they're discouraging use, but actually are doing the opposite.
Yeah. Whereas if it was coming into as a tax for the city to make determinations about how to spend the money for youth education, I completely
exactly. Exactly. Yeah. There was a brief period about 25 years ago where the federal government was encouraging tobacco companies to do education campaigns directly, and those campaigns were exactly what you don't want.
Yes, exactly. Thank you for that. Also, because I'm on the planning commission, I really need to be clear about what this process is. So on page 20. Maybe this is the original one, but
yeah, you've been actually citing to the old
yes. I'm sorry, I was going through that document. Okay, so just to be clear on this process now, so the any permits would come to the planning commission, and we would actually decide which 3 applications, if we put a limit of 3, let's say, and we don't go to your option, then we would actually define who of the applicants gets that permit. And if the applicant who wasn't chosen wants to appeal to the council, they can do that.
Actually, no. That the whole concept of having multiple applicants for a slot is essentially eliminated from this ordinance. What happens is, before there's any real processing or any real applications or even a real plan, you have the pre-application and lottery, which is essentially all the people who would like to apply for regulatory and zoning approval put their name into a hat in a pre-application. Then if there's one slot, you draw one pre-applicant out, and that person is able to go through the rest of the process. And the others are basically in holding until the next lottery.
Okay.
So You never have a situation under this ordinance where the planning commission or the city council is deciding between applicants. There's one applicant for one slot, and they are just like any applicant for a CUP, are trying to come up with a set of use restrictions that will satisfy the planning commission.
So essentially, it benefits the planning commission and the council from ever having to do that competitive process, and it really absolves us from that.
Correct.
Okay, great, wonderful. Okay, and one just last clarification. Councilman Frank O'Connell was talking about the federal regulations, and let's say that after November, we suddenly now get legalization at the federal level. Does the things that we are going to approve in this go around on the November ballot, would anything need to change as a result of just that, or?
Well, I can't predict exactly how legalization at the federal level would be implemented, so it's hard to answer that question. If the federal government were to just essentially take itself out of the business of regulating the use or sale of cannabis, at least in retail quantities, then it would fall to the state regulations, which are already in place. And your process is fully in line with the state regulations because the state rules grant cities the ability to entirely prohibit cannabis uses or to zone them however they'd like. So if the federal government took itself out of the cannabis regulation business altogether, it would not affect your process at all, except that the businesses would now be able to get bank accounts and wouldn't be worried about being rated by DEA, and also would probably be able to get financing and contract with businesses that are a little larger and more stable. As opposed to having to work in this cash-only business. It is possible, if the federal government decided to legalize cannabis, that they would create some sort of federal law that allows it, but creates certain restrictions. And I can't predict what they would do.
Sure. Well, you just clarified two options, and I was only focused on one, so thank you.
Okay.
Thank you, Mr. Mayor.
Go ahead. Thank you, Nancy, and then Frank, and then Gail.
Thank you, Mr. Mayor. A couple of things have come up in my mind due to the discussion. One of them is the fact that these are cash-only businesses, which I knew, but then you begin to think about, well, what does that mean as it reflects to the city receiving money? If they are not allowed to use the banking system and monies have to come to the city, currently it says annually, this new one you suggested quarterly, that's a large sum of money, cash, that would come into the city unless there's some other mechanism. Can you speak to the issue of how the city would be receiving the taxes, business license, and other fees that might be associated with this if you do not have access to banking?
That's an interesting question. And I actually don't know what these businesses have been doing in other cities. Does any staff member know about that?
I can help with that. And if I misspeak, Eric Frost is on the phone as well. The system we had set up was what other cities are doing as well, is you actually meet them at the bank and you deposit it directly at the bank. So they don't bring the cash to the city or anything else. So we're able to receive the money that way.
Oh.
Okay, that's a relief. We don't have the security that they have, so that is truly a relief. The other thing that was just discussed, Commissioner Biala brought it up, was what should happen should federal law change. And is it possible to put into this ordinance just something as simple as this ordinance will comply with state and federal law? So that way, if something new happens, we are already saying that we comply with federal law.
Well,
Can't say that.
first of all,
Okay.
we can't really reference federal law in our ordinance because right now these businesses are not operating in compliance with federal law. So I think it would be difficult for us to make any sort of affirmative statement about how changes in law will affect it. We are subject this to a large extent. The state has the ability to preempt a lot of our authority, but have not chosen to do so. And the exact limits of what they can and can't preempt is kind of too complicated and too speculative to go into here. I'd prefer not to speculate on possibilities of changes that the federal government could do in their law or their enforcement and how that would affect us. But I think the real answer is that it's certainly possible that part of our ordinance could be made unenforceable by a future change to federal or state law. And if that happens, then, and that happens fairly often with state law, and what happens is eventually you take the laws off the book. In the meantime, they start unenforceable. It will be much easier once this ordinance has been adopted and the council can make its own amendments rather than going back to the voters. It'll be much easier to make changes to get rid of non-conforming provisions because you won't have to go back to the voters.
Okay.
Anything more, Nancy?
No, that's it. Thank you.
All right, thank you. Councilmember O'Connell?
Thank you. A question for Matt or for Christy. The Planning Commission recently recommended the forwarding of the 5 applicants to the City Council, which in fact we addressed. At the time in which that was in front of the Planning Commission, were they aware of the flaws that existed in the ordinance?
Well,
I'll let Christy speak to that, I guess, more directly.
to some extent, well, yes, they have been made aware of the flaws in the ordinance and the yes, they were made aware.
Were they provided?
If I could add,
were they provided with an actual copy of the August 2nd, 2018 HDL report on this?
The HDL report, Matt, I don't believe they were not.
Yeah, they would not have been.
Well, that was really outside of the Planning Commission's purview of review.
Yeah, because that was an economic report.
Correct.
Councilmember O'Connell, if I could just add that although, we all agree that there's some certain flaws within the ordinance, we did come up with a process that was fair and open and was, we think, equitable for everybody involved. So we think we did process applications completely correctly at the end of the day.
No, I'm not saying you did, but I noticed in the minutes of the meeting that I think it was Chair Burnett made reference to the flaws that existed. And I was just wondering if that was addressed in any type of detail. Were they aware of the fact that it's in violation of federal law, cannabis?
So the federal law did not come up in the discussion in the proceedings. No.
Great. Thank you.
Thank you, Frank. Okay, Mayor Pro Tem Morton.
Thank you. So Mark, you answered one of the questions, which is if council has discretion to amend the act, then we would be able to take out non-conforming provisions if there's a change in law, which is great. The other point of discussion is to Commissioner Biala's statement, going through the question about do you want 3 permits or as one side of the argument, and you've been able to articulate the second side of the argument is let market demand do just supply and demand, rely on economic theory, and whatever survives, survives, and you put them out there. I think our police chief also said, well, slow down, because in her experience, sometimes neighborhoods are affected and it affects policing. So the question is, if this ordinance draft that you drafted to put in front of the voters said 3 permits, is that a term that can be altered by council should we find 3 years from now, a year from now, that unlimited is fine or 1 is fine?
As this ordinance, my ordinance is currently drafted, those would be provisions that could be changed. The city council would be able to change the limits. You could change the ordinance that's going before the voters to foreclose your ability to do that.
Right.
Okay, so currently it does, and then it allows what I'm looking for is to preserve the interplay of market conditions versus our policing concerns and efforts. So if this allows us to make those adjustments as we see what happens, I think that's beneficial. So
yeah,
thank you.
as this is as written right now, if the voters approve this ordinance, you would have the 3 and 3 and unlimited rule for the uses, but the council would be able to change any of those numbers to any number it wanted or unlimited.
Perfect. Thank you.
Thank you, Gail. Mark, following up on Gail's discussion, are you aware of any cities that have limited the number of permits per city area so that we don't have the accumulation in any one area?
I am not aware of that. I certainly think that we could write in some sort of provision like that. The only issue with putting in limits is that once you put in a numerical limit, you potentially get into the issue of either having the competitive process again or having this gate with, you let one person in, wait and see how they work. Then if they don't take the slot, you let another person in via lottery. So anytime you put in a numerical limit on something, you kind of have a choice between the competitive approach or the lottery gate approach. Whereas if you put in some sort of buffer zone requirement, then it becomes essentially, the first to get approved gets it. And then that blocks future applications.
Right, so we already have 3. We don't know if they're actually going to open their doors or how long they will last after they open their doors. Hopefully they'll all open for a long time. But since you already have 3, regardless of whether you go lottery or competitive, why couldn't you put circles on the map and say inside each circle there can be no more than 2? And right now 3 of those circles have 1, or maybe one of those circles has 2 already. But I don't understand why circling and limiting per circle the city would have anything to do with whether you do a lottery or competitive.
Well, it doesn't have to do with whether you would choose. It requires you to essentially have either a lottery or competitive, but it doesn't require you to it doesn't lean towards one or the other. The issue is that when you have a numerical limit, you either have to have a lottery with one person going through to figure out who gets to fill the slots in that limit, or a competitive process, or I suppose you can do a scramble where everybody who wants to puts in an application, and then the first person to get their application all the way through wins and gets the slot. And then everybody else who's scrambling, their application is cut off. But I don't know, if you have a numerical limit, I don't know a way to not have one of those 3 things happen. Whereas if you have unlimited with no numerical limit, then you don't have to have any of those 3. And you just can do it the way you do for other sorts of businesses.
Okay. All right. Thank you. I do want to go to public comment. We could go for a 3rd round. What is everyone's pleasure? Do you want a third round or do you want to go to public comment? Nancy?
Public
I would
comment.
like to go to public.
I have one brief comment that I'd like to make before we go to public.
Well, this is a time for questions, and we're
Well,
trying
this
to
is
limit
a
the
question.
comments.
This is absolutely a question. It's not a comment on what we've discussed. It's a question about what we've discussed.
Okay, go ahead, Nancy, and then we'll try to go to public comment unless anyone
All
has a
right.
burning.
My question is, in the ordinance, if you use language that, number one, you're already using language for zoning where certain types of cannabis businesses would be allowed. And we also have in the ordinance language that relates to distances apart. Doesn't that deal with the issue that has been talked about where you don't need a number because you've already described that you have to have a certain amount of distance between cannabis businesses, and you only have certain areas that can be zoned for cannabis businesses?
Yes, it does. It does create something of the scramble situation in that, let's say you have two folks who are applying and they're applying for locations that are next door to each other. Whoever manages to work through the process first wins, gets their location, which then sends the person who's been a little slower back to square one. If there's no numerical limit, then what square one means is they have to come back with a new location. If there's a numerical limit, then it means they have to wait for a potentially unlimited amount of time. But either way, anytime you have that kind of scramble, there are always potential problems with an applicant thinking that your planning department is working on one application faster or is intentionally slowing down the process so that the other one can get to the finish line first. And those sorts of situations can get kind of heated and are probably best avoided, but sometimes it's unavoidable. Sometimes you just have to say, okay, we're only going to allow X of these within one block of each other, and whoever makes it past the post, great, and the other person, sorry. But it's probably best to minimize the amount of scrambles that are going to happen.
Okay, thank you.
You're welcome.
Thank you both. Okay, let's go to public comment. We have a couple hands up so far. We'll start with Wes. Good evening, Wes.
Good evening, Mayor. Good evening, City Council members and Planning Commissioners. Attorney Mark, my name is Wes Clark, and I am unfortunately one of the applicants that did not win. We were a turnkey solution, and we were ready to get open. Our goal was Labor Day to Halloween, and I have to believe that being non-union did not come into a factor, even though all three locations were union, and I am pro-union and being able to do that. I also have to believe that displacement is also come into a non-factor because Robert Rathie said it. My attorney spoke to Robert Rathie saying that displacement was not going to be a factor, and Robert said that several times. But yet, I've done the most community benefits. I scored a 100. And I have spent over $57,000 of my own money on this city and have driven countless hours to clean up events and put my blood, sweat, and tears into this. I need to know that if one of these companies that are promising to revitalize the city, I'm okay with losing to them, Attorney Mark. I'm okay with losing to someone that wants to put the $750,000 it's going to cost to rebuild the Mortimer Center, or the other company, Steezy, that did not score a perfect score. I'm okay with that. I can take that. But what I can't take is them not keeping that promise and then being able to move somewhere else. That can't be allowed. That has to be passed on to us or Mr. Palma, who wanted to remove gas tanks for you guys. How is that fair? I have cleaned up parks next to Councilmember Urrutia and Mayor Delgado, and I have done everything I possibly can to show this city that Audra and I and the Beyond Hello team were going to be great for this city. But how are we just going to get spit in the face and let them just move? The conditional use permit must be revoked. They can't get away with highway robbery. If they want to rebuild, great, awesome. I'll be the first person in line to buy an edible. But if they are going to put in for a move, be allowed to move, come on. Jesus.
All right. Thank you, Wes. And we'll obviously discuss all these points that come up in public comment session. Let's go to Grace.
Hello, Mayor and City Council. You can hear me okay?
Yeah, good evening.
Good evening. First, I wish from day one this had been the process. Both my husband and I had voted no on the initiative for different reasons, and I do truly wish this had been the process from day one. Mr. Mandel, I have to thank you. This has been a fabulous presentation, and I want to thank all of you commissioners and council members and the mayor for your questions. I'd like to know if it's possible to get a copy of the PowerPoint that Mr. Mandel made initially at the beginning tonight. I think the most complicated thing here is going to be the lottery with limits, although I just got thrown off when the phrase buffer zone requirement came up. It's a little bit, I just received the packet, your packet today, so I didn't really have a lot of time I had no time actually to look at it. And I'm glad there'll be 2 more opportunities, Planning Commission and City Council. I echo Brian the issue about hours of operation. Please don't link this in any way to the hours of liquor stores. I will say up front that I do utilize a dispensary for a balm for my mother, my 94-year-old mother, and for a sleep aid. And that dispensary, Big Sur Botanical, closes at 7 p.m. I don't think we need dispensaries open until 11:59. Yes, please get rid of this whole thing linked to donations and volunteer hours. It always seemed pretty absurd to me. I'd like to remind you that when you as Planning Commission and when you as City Council members make the modifications to this ordinance that will go to the voters, we're not looking at what other cities are doing. It's a majority of each of your bodies to decide what's best for our town. And as much as it's nice to look at other cities and see what has been successful for them, partly I'd like to know how many dispensaries are in the different peninsula cities relative to their population and relative to their geographic footprint. But really what I want to know is what are we going to decide is best for our community. So thank you very much for the time to allow me to speak.
Thank you, Grace. We'll go to Joey.
Thank you. I just wanted to say that I do agree with Mayor Delgado. I do kind of wish we would have gone through this in a way where we essentially redlined the existing ordinance. It would have been easier to follow, to know what was wrong with it and what could be better with it, but it is what it is at this point. In regards to the operating hours, state law is now at 10 p.m. for dispensaries. At the time the ordinance was proposed, state law was 11:59 p.m., so that's why there's a discrepancy there. I think one of the major issues with the existing ordinance was the amend and combine process. And that was also a major point or contentious point in the Seaside process. It makes things much more complicated and oftentimes unfair. So I'm glad to see that that is potentially going to be eliminated. In regards to the pre-application lottery, that is concerning to me. I understand Planning Commission and Council's point of view on being in the tough position to make those sort of decisions, but a lottery can pose a lot of problems. I've seen it in other cities, mostly in Southern California, where they've tried lotteries. I'm curious what would prevent someone from applying with maybe multiple entities at one location, or we spoke about large corporations, tobacco, and things like that. What would prevent them from just getting a bunch of locations and applying to increase their odds in the lottery? Things like that always become an issue. In section 5.80.260, we're talking about eliminating the option for on-site consumption, and I'm sure, because I know the council pretty well, that's probably not something Marina's really ready to do. So I recognize that, but I do want to make sure we put it in a way where that can potentially change in the future, which sounds like we are with what Mark is trying to do. One thing to keep in mind is it's also good to allow the applicants to start the state licensing process immediately, because those licenses can take about 2 to 3 months to obtain. So that's more of an administrative comment that will help your applicants get up and running faster. When it comes to odor control, one idea I had was we could research any complaints that MBARD might have. Talking to Monterey County, they said that MBARD is one of the organizations or agencies that handles odor control complaints. So I think it'd be interesting to know how many complaints exist within Monterey County, so you guys can get a better gauge on the reality. If we're going to talk about the number of licenses or permits, if we do go down that road, I think it may be worth discussing non-storefront deliveries. These are licenses that allow you to offer retail through a delivery service. Nobody's allowed to come to your location, so there's not much impact on the public. It's one way for the city to generate more revenue, get multiple operators, and just have more options for people to apply for cannabis businesses in the city. I hope that we don't postpone the other licenses until 2021. I know that some of us were kind of waiting to see where the chips would fall when it comes to the retail dispensaries before applying for these licenses. And so if we were to change that, it would be unfortunate. And I don't see much of a need to do that. I think it's a pretty straightforward process. And I echo what Bruce said. A lot of cities are seeing much benefit to those licenses in regards to generating revenue, but also creating more jobs within the city. So I hope we don't change that. I just wanted to comment quickly on banking. Banking options are better than ever before for the cannabis industry. They're constantly improving. There are several options now for cannabis to acquire bank accounts. It's, again, not perfect, but it's much better than it was 2 years ago. And I'm glad to hear that you guys already have something worked out for the cash handling process for people paying taxes. Monterey County Fire Department does something similar where you just go to their bank and you can deposit it directly into their account. Last comment was in regards to, it seems like essentially some sort of a rent control in there where you're talking about market value of the rent. I'm wondering if that market value is going to be just based on the general industry. Is it based on cannabis specifically? Because as some of you know, cannabis operators generally have to pay a higher rent because landlords just know they can do it, so they do it. So those are my comments, and I appreciate the time.
Thank you, Joey. Any other public commenters? We'll go to Paula Pillow. Hello, Paula.
Hi, Bruce. Hadn't really written up anything for this evening, but I've listened very carefully to this. And a couple of comments that I want to make on this process more than the ordinance as it's proposed is number one, in February, I believe it was 2018, we had a strategy planning meeting. And at that meeting, Council Member O'Connell had suggested that we take this to a vote of the people rather than the council making a decision, and had suggested at that time that the ordinance be designed by our own attorneys or consultants, and that it would have, and in my opinion, that would have been a better way to go. That was my opinion then. It's clearly my opinion now. And it concerns me that we have spent all of this time, staff time, trying to sort this out, and here we are again. And so, you know, please don't do this again. I really feel it was an election year ploy. That's my opinion, and I think it's the opinion of many others. And I think that's unfortunate because now we have to go back and do this all over again. I want to speak to the comments that were just made by Wes, and also they're very similar to those that were made by Saul Palmas. It doesn't endear you to the public in this city to threaten and have bad behavior in these meetings, to be bullying and threatening like Saul was, saying, well, you're never going to get anybody else there for 50 years, or Wes. It's like a temper tantrum. And you don't get to get licensed in this city because you've gone around and picked up trash. This is why you need something that is much more clear, that you do not get favored this way or another way, and that the lottery is a superior way to do that. So I am very distressed that we're spending all this time on this. I know we have to at this point, but please, let's not do this again. And please, for people who want to apply, do not threaten, yell at people, and bully, and try to gain special favor. Thank you.
Thank you, Paula. We'll go to Brandon Jasicki.
Hello?
Yes, hello, Brandon. Thanks for joining us.
Thank you. Thank you, Mayor and Council, for taking this up. I think that the discussion's been very healthy and good. And part of my background in this industry is that I worked with a lot of counties and cities in licensing and ordinances for cannabis throughout the state over the last 5 years. And I think the approach by your folks here is good. And I would say that, you know, a lot of the comments that I wanted to make were already made by my good friend, Joe Espinoza. And I would just echo all that he said in terms of, you know, the things that you want to be cognizant of and look forward to. In my view, I think that it's, even though we just went through this competitive process and we were fortunate to be one of the ones selected, I kind of think it would be, I look at the more free market approach as opening it up to more and let companies do their best, and the ones that fail.
Always muted.
Brandon, I'm trying to unmute you. You ended when you said, let those fail.
Can you hear me now?
Yes. And
Okay,
you
sorry.
were cut off after you
I,
were talking about failing.
right. Sorry. Yes. What I was just saying is that just that I believe more of a free market approach. So I wouldn't think it would be good or bad to restrict the city to 3 or whatever, but that's just my personal view. But other than that, I think that the approach and the things that you guys are doing is healthy and good. And as one of the applicants, we were aware of some of the flaws with the existing ordinance and the existing process. But I will say that staff in working with us we were all aware, and everybody I think was pretty cognizant of the process, and I think it was at the end a fair process. So I thank you guys for that. And and I'll just say too, for our vantage point from our company, we do have banking. So I know that was one of the issues that was brought up. And as Joey said, that's becoming more and more of an option for cannabis companies. But our particular company, we have banking, so we'd be sending you guys checks or wires. Thank you.
Thank you, Brandon. Christina Medina Dirksen.
Hi there, everyone. Thank you for having this open discussion this evening. It gives us a chance to apply and analyze what we learned going through this long process. And again, if we would have started this from the get-go and had the support, we wouldn't be here today. But we tried. We tried to get it to the city quickly, and I'm glad that it's here now. When we talked about taking into account things like the lottery, I worry about that. While it may appear fair, it's not going to really ensure that maybe locals have a competitive chance. Randomness could also, I think somebody also mentioned, you might have really big companies coming in and dominating the landscape, so I worry about that. As we move this forward, I do appreciate the input from the industry experts, and I think we should ensure that they are part of the process because they are going to know how this actually plays out for us, it's a bit of an experiment. When we're talking about hours as well, I do not believe we should go super late, but we do have to take into account work hours. Not everybody gets out of work at a reasonable time, so maybe a 9 or 10 o'clock hour is not unreasonable around here, considering that we are a working community. We have to keep that into account. Next thing I wanted to say is I do appreciate the applicants selected had commitments to improvements to improve our city's infrastructure and the facade. We really need to work on improving our image in terms of, when you're driving into town, what it looks like. So I just want to say I'm thankful for your careful analysis and look forward to hearing this layout with public input. So thank you all very much for your time and effort into this issue. That's it.
Thank you, Christina. Anyone else in the public wishing to speak at this time before we close public comment? Okay, not seeing any new hands going up, so we'll close public comment. And let's see if there were any questions. I know there were lots of comments. I did not note any questions. Did I miss any that others may have noticed? Because I would like to answer any questions that came up.
Mr. Mayor, I think there might have been a misunderstanding by Wes Clark about the existing permitted applications will still be in place under the same rules. We're just talking about for the new ordinance. So that businesses will not be able to move under the existing ordinance. That's all.
Okay, I'm glad to hear that. All right. So this has been a study session. Let's turn it back to the Planning Commission and the City Council for comments. So you're not restricted to questions or comments. You can ask or comment as you wish. So let's go to Brian.
Thank you, Mr. Mayor. So based on everything I've heard tonight, I think for me, there's two top issues that come out on top really, and those are odors and protecting youth. I will say, and I think Joey brought up a good point about contacting MBARD. I had a conversation with MBARD regarding some other odors in our city, and during the course of that conversation, we started talking about cannabis, and that individual told me that he's never been to a cultivation site that he could not smell odors of cannabis outside of. And then in terms of manufacturing, I just want to say that we maybe need to better define what we consider manufacturing to be, because if it's taking raw plants and tearing them up, that's likely to be more odorous than the cultivation itself. Secondly, in regards to youth, I just think we really need to be cognizant of what we can do to protect young people from becoming customers before they're legally able to. And I think that possibly two ways that have been identified that you can do that is one, regulating signs. In San Diego, they are getting more strict about signs, not less strict for that very reason. And then two, maybe just really considering where this use is allowed in proximity to other areas, whether that be parks, schools, or other places where youth may congregate. I really appreciate the discussion tonight. Thank you.
Thank you very much, Brian. Okay, others? I'll mention a couple things. I think it's good if we have background checks for everybody, not just the upper management. And I'm unclear from our discussion what our current ordinance says, but I think it says that everybody has to get a background, and I think that should stay. And if it doesn't say it, that seems like a no-brainer. I think we should fix the alcohol problem. I don't think cannabis ordinance should have anything to do with alcohol rules, but if we want to look at the alcohol rules to change them in some way, that's fine. But I think they should be unlinked to the cannabis ordinance. I think we should tighten up the odors. If Brian is correct and that there is no cultivation that doesn't smell. And if there's manufacturing that you can't prevent smells coming from them, I think we need to know about that. But I think also that our current ordinance and our conditional use permit already takes into account odors by saying, if you have odors, you will be shut down. So it'd be nice to hear about that next time we come back, because I think that we shoot ourselves in the foot if we create a moratorium on certain businesses before we've had any problems or been told by other cities that testing and manufacturing and distribution, that those non-dispensary businesses cause problems. We know that they bring in revenue. We know they bring in jobs. We know that downtown jobs and revenue creates side effects to help other businesses downtown, which is something that is one of our goals. And so I would hope that we don't do a moratorium unless it fixes a problem that not having a moratorium allows to happen. I really like Mayor Pro Tem's introduction of the concept of large corporations, and we had other people follow now and then tonight. I don't think any of us want Marlboro to come in and take over, and that was one good thing I think we can all agree on with the competitive process, is that the applicants strove to have Marina resident employees, local ownership, and union backing. Those three things, whether or not they were a criteria, two of them were. Well, the employees local was a criterion. But I think that if we help ourselves and help our locals and we discourage large corporations, I think that that's a good thing. One of the biggest problems with the ordinance that's in place right now is that it didn't speak to local displacement of businesses that exist today. If we were to switch just to a lottery, that doesn't speak to displacement. And you could have more displacement issues with a lottery than what we already went through recently, which I think was a lot of the stress, was we were lamenting the fact that we were replacing existing businesses with incoming cannabis businesses. So I don't know how to go to a lottery and prevent displacement, but that is something that it would be nice to look into. On the risk, it sounds like things are getting less risky, not more risky. We have had some robberies at our banks because they're known to be places with a lot of cash. And so I understand the concern that there's a risk of businesses, but unlike banks, our city police chief told us that our current ordinance requires 24/7 security. And that might be why we don't see in the state of California risk playing out to increasing armed robberies or other kinds of crime at dispensaries and other marijuana businesses. There are occasional crimes, but not at a higher rate that I've heard of than any other businesses. The hours, if they go from 11:59, they have to go at least to state law down to 10 o'clock. And if I work a late shift, I come home from a restaurant or somewhere else, and I need to get a cannabis product, I don't see why it would have to close a cannabis business 6 hours or earlier more than an alcohol business, because probably, those people might just go to get alcohol because it's still open and they look for the next thing. Or they're trying to get medicine and they can't when they come home from work, even though they have some kind of ailment that's bothering them. So I don't know that we have a problem with the timing, except for state law has changed to 10 p.m. And of course that needs to be addressed. I would like the police to find out about park proximity. We don't have alcohol restrictions on distances to parks and businesses that sell alcohol. I personally think cannabis is a lower risk drug than alcohol. And so it doesn't make logic to me to be more restrictive with cannabis than with alcohol. But if precedent shows us that cannabis businesses are causing problems with youth in parks or adults in parks, then I think that's a problem that we should avoid. But if a little bit of looking from our police to other police chiefs finds that park cannabis proximity have not been a problem, that is where it's worth going to other cities. Not that we don't want to choose our unique way that's beneficial to Marina, but I don't think we need to fix problems that don't exist in other cities, because it's unlikely that they would be a problem here uniquely to us. But that's my thought. I agree with the signs. If signs are causing a problem in other cities like San Diego, then we can learn from those mistakes and not repeat them by doing something about signage that is unique to Marina in Monterey County anyway. Okay, so now let's go to, thank you everybody. Let's go to Kathy and then Gail. Go ahead, Kathy.
Thank you, Mr. Mayor. So just to follow my previous line of thinking, as well as what Brian just said about the youth, it's not just preventing access. I really believe that we need to rely on medical research to emphasize the deleterious effects long-term for chronic use in youth and developing brains. So I'd really like to have that as part of the education. Also, it seems like since we started and it's more palatable to everybody to do the 3 limit scenario, but also to build in that the city council has the ability to change at some point without another ordinance, but to change to unlimited, I think is a very good idea as we go forward and we understand more of the implications of these kinds of businesses in Marina. And I think that's it for now. Thank you.
Thank you, Kathy. Mayor Pro Tem Morton.
So I think a lot of the issues that I wrote down were covered by other individuals, but one of the things, of course, was to revert ordinance section 1700 back to just alcohol, that we need to do that cleanup, that all employees will have background checks, not just the management employees. Signage, odor, we talked about that, changes adopted by council, and I definitely did think the moratorium for allowed council to continue and the planning commission first to continue to look at what kind of zoning rules we need for other than retail dispensaries is important. And I just had one quick question to maybe Eric, if he's still here, and this idea of cash and how they pay business licenses. If in fact a business could set up, if the city could set up, in my world we call it a trust account, where funds get deposited so that the cannabis provider could go and put in monthly deposits, could deposit what they think are their anticipated business licenses on a more frequent basis, and then we just bill against that or true it up at the end of a quarter. Just a thought, just trying very hard to make this, not that our city staff has to be at a bank with someone in danger that it's an armed robbery at that moment because of a repetitive pattern. So I'm just looking for other ideas that might keep Eric or someone in Eric's position or who he sends safe. Thank you.
Thank you, Gail. And a follow-up question that came to mind with Gail, I think Matt said earlier tonight that we have some non-dispensary cannabis business applications in the pipeline. Matt, can you summarize those for us? And then I'm going to ask how they might be affected by a moratorium in November.
I sure can. If you give me 1 second, they're on our website.
Okay, while you look them up, Bob Rathke,
okay.
How would a passage of a moratorium, if it was included in the November ballot, affect pipeline projects?
I think those projects would be on hold until the moratorium expired, and the council had the opportunity to develop, if the new ordinance was adopted with the moratorium, and the council had the opportunity to develop the regulations for each specific business. I think they would be on hold, and then they would be subject to those regulations.
So if they're already spending months as of today and more months as of November to work through the application process and a moratorium passed, they would not be grandfathered in. Their efforts would be put on hold.
That's my understanding.
Bob, I think we need to do some research on this one
Okay.
and bring options back to the council.
Okay.
Mark, do you say that because of concern about stopping pipeline projects, or what is your thinking?
I say that basically because I need to take I need to look at some of the rules about how moratoria apply to planning codes, and also look at what options we would have. So it may be that we can set it up either way, or we may have the option, we may be stuck with one option or the other. So we just need to look.
Can you make that a little bit bigger on the screen? I'm sorry to interrupt you, but I cannot read it.
And Mr. Mayor, we do not have any pipeline projects currently for anything other than dispensary currently.
Okay, thank you, Christy.
And Christy, those are manufacturing applications in connection with the dispensary. Is that what we're talking about?
That's manufacturing or delivery or anything like that. Right. Nothing has been applied for. The cultivation application was withdrawn.
Right. Thank you.
So to clarify, these applications before you are ones that were submitted for the business permit, which is the process where HDL goes through ranks or scores and does all the background checks and all that stuff. So that's what these three in the bottom represent. And
can you make it larger, Matt?
Mentioned. I can, but then you're not going to see the whole thing. So do you just want to see the names primarily?
Well, I guess if
and the location.
Probably want to see the type of business if it's a non-dispensary.
Yeah, so it's these three right here. The top one. So Paul Davis Drive was the one that was denied for cultivation, correct, Christy?
It was denied on a 3-3 vote, so it was denied without findings, and then it was appealed to City Council, and then the appeal was withdrawn. So really, no official action was taken on the cultivation at 3343 Paul Davis Drive. We have not received applications for let's see, JC Marina Ventures or Design Marketing LLC at 326 for manufacturing distribution. And then if you can scroll up, Matt, to the top.
Yeah, and if I could just finish, I guess, with the process, though, is these applicants, the top one having followed through on it, were all notified that they were qualified and could enter the process for their non-dispensary permit. So the other two chose not to yet.
What are the business types? Because I can't read the text that's small font.
One is distribution. That was JC Marina Ventures for the same location at 3343 Paul Davis Drive. And, that may have been tied to a dispensary permit application, so they may not want to follow that. And the design marketing one is for manufacturing and distribution. And that was at 326 Reservation Road, Suite G.
Is that element 7?
No, if you scroll up to the top, that's what I was saying. Go to the top, Matt. So initially, element 7, Marina, applied for a retailer, which they received the use permit. Manufacturing and distribution, which are separate use permits. And so they received the conditional use permit for retailer, which is what we just went through. They would need to go through an additional application process for manufacturing and distribution. And it sounds like they have abandoned manufacturing, but will be looking at distribution.
So, legal opinion, if they start to proceed toward distribution permitting, they could theoretically get their permit before November, And then if moratorium was passed, what would happen? Would they grandfather in or have to force to close that business?
Well, once you have a permit, you're definitely grandfathered. The only question that I think is out there is what happens to folks who are in pipeline, and what counts as being in pipeline.
All right.
And I think you just answered your question, though, Mr. Mayor, and that these people would apply and follow through with the process prior to November if they knew that was a risk to them.
Okay.
So,
Thank you, Christy and Matt.
You're right.
Mayor Pro Tem Morton?
But part of having this on the November ballot, and I do like that Mark is coming back with what are the possibilities, but just if it is going to be on the November ballot as a moratorium and that gets passed by the voters, the council would be able then to be working on what we want and implementing those strategies, correct, Mark?
Yes.
So then the moratorium could end the day after the election, basically, or January 1, because we've satisfied our criteria and can immediately amend what we want in the ordinance.
Correct. Yeah, any amendments that you're going to make can also include repeal of the moratorium. So the moratorium is just in place because otherwise, if you didn't have the moratorium, then between when the ordinance goes into effect, which is, I believe, 7 days after you certify the election results, and whenever you get your new rules, your new amendment in place, people would be able to do applications with essentially no restrictions, because right now we don't have any restrictions written into this ordinance.
So that is my thinking about the moratorium, is that it prevents people from having detrimental reliance in the future on what we have written, and allows us at this time, between now and this is going on a ballot in November, that we address all these concerns and we're ready to go immediately with what we want to implement. So the very first action of council would be repeal the moratorium, and here's the new criteria. And in the meantime, you don't have people in the pipeline relying on what is not a good process or has proven to be a process that's been very difficult for us. It doesn't prevent those that beat the November vote from going into place. They're in the pipeline. If they want to go forward, that's fine. But I think I'm looking for a win-win, that we have time to do the diligence that all of us as panelists tonight are asking the city to review and look at. Thank you.
Thank you, Gail. Councilmember O'Connell?
Thank you. Basically, the original process that was taken to get this initiative going was obviously flawed, and it wasn't a case of an intentional act by the mayor to not handle it properly. And I would assume that the people, many of whom signed the petition, were not aware of the flaws that are in the ordinance. That's all behind us. The thing is, we have a deadline of August 7th. If we do not get this on the ballot to let the people make a decision that would correct these flaws, we are going to be looking at a situation where we either put it on the ballot next year at an additional expense of approximately $40,000, or wait until 2022. I think the fact that the moratorium would be able to be lifted by the council's action would result in the decision being made with a lot of knowledge and understanding by the council and the public as to the meaning of it. We are now spending money that, if we had handled it in a different way and brought it before the council back in February of 2018, we wouldn't be in this predicament. but we're here. And let's not miss the date of August 7th. I personally don't want to ride on an ordinance that is flawed. The public knows it's flawed. The applicants know it's flawed. And the potential of getting the city in trouble financially as a result of those flaws can be avoided if we get this on the ballot and it in fact does pass. So I'm hoping the meetings can take place, the planning commission can do their decisions, we can get it back to us and get it addressed, and let's see if we can get this on the ballot, although everyone I think knows what my position is since it is in violation of federal law. So thank you.
Thank you, Frank. And I agree with you 100% that the flaws in this were the reason that we're here tonight. I think tonight we've gone way beyond the flaws, and we've all, including myself, put some value judgments into what we like and what we don't like. We did not restrict our conservations to the flaws. For example, distribution, there is no flaw in the ordinance regarding distribution. And by trying to do a moratorium on distribution, that's not because there's a flaw, it's because we want to take a deeper look at it, not because we have pointed to a flaw tonight with distribution, but we want to take a look at it. Odors is one of the main concerns, and we almost had a business get approved, and the conditional use permit took care of the odors by saying if there were odors, that business would be out of compliance and would need to shut down. So I think that we've gone way beyond the flaws, which was the original purpose, and now we're becoming much more restrictive. We're talking about earlier hours. The hours weren't a flaw, except the state law changed. So the fix, the cure to the hours is to go from 11:59 to 10 p.m. Anything earlier than that is not fixing a flaw, but it's inserting a new value judgment. And the citizens of Marina clearly prefer to have more jobs and more money for more services. And Cannabis Initiative was in part to try to bring that benefit to all of our downtown. And so by trying to become more restrictive, we're going against what the voters overwhelmingly passed because we're going way beyond the flaws. But if we had a short list of the flaws and a correlating list of cures, this would pass much more quickly through the process to get to August 7th. The messier that we make it because of all of our value judgments trying to become more restrictive, the harder it's going to be to finish it by August, and the harder it's going to be to get it passed. And I think a moratorium on certain businesses is a perfect example of not fixing a flaw, but coming up with a cure for a problem that hasn't been demonstrated tonight. And I hope that we do get some due diligence done on parks and testing and manufacturing and distribution so that we can be told by our staff, yes, there is a problem. There is a flaw in the ordinance because it leaves testing or other businesses hanging out there in a way that they can harm our city, and we need to fix that. But if indeed they come back and they say there has been no problem with testing or distribution or some other business, for us to continue beyond that toward a moratorium, it's just making work for staff. And when we say that staff can at any point get on this and fix it so that we can lift the moratoria, that is not the way we work. We are very slow making any change because our staff plate is overwhelmed. And just thinking that we can have them jump on cannabis to do more than they need to do is going to displace our work on something else that we are trying to fix that's very important for us. So it's not an unlimited staff availability to continue working on cannabis. So we should restrict their work to what's needed to fix demonstrated problems. Okay, Gail, I'll turn it over to you. And then Councilmember O'Connell.
I would like, I understand the mayor has a differing view, and I understand that HDL, the experts have told us our ordinance is flawed, and we have professional counsel that is saying, here's recommendations of ways to fix it. And it has to go through a process. It's going to go to the Planning Commission for their own independent review. And after hearing all these comments, our attorney, Mr. Rathie, and Mark Mandel, and staff may alter this. But the action item tonight is to receive the presentation on the draft revisions to the city's 2018 voter-approved cannabis activities ordinance. I make that motion, and if I get in a second, I would just
second. Councilmember
Thank you.
O'Connell.
So,
Thank you, Gail.
so I'm just trying to say to your, and all of us will have an opportunity to weigh in and make those votes on what should happen, both at the Planning Commission and at Council. But tonight, I think none of us are going to persuade each other in its entirety, and it's just, let's see the report and conclude the meeting. Thank you.
Thank you, Gail. And the point of tonight is questions and comments. And Councilmember O'Connell, you're next.
I was going to say exactly, pretty much the same that Mayor Pro Tem did. Is if there's a need for a vote, I'll call for the question.
We do have Councilmember. We have a motion on the floor, so a call for the question is to stop all comment. We do have a commissioner wishing to speak. Let's take it to the Planning Commission first. If you want to run a vote for calling the question and stopping discussion, please do so. Chair Burnett.
Yes, I call for the question. I agree with the motion to call for the question in debate.
So, Councilmember, Commissioner Burnett, can you please, or maybe Matt, you can do a roll call vote for the Planning Commission to call for the vote, call the question?
Does it need to be seconded? I'll second.
No, well.
Sure.
Okay, we have a motion and a second for the Planning Commission. Matt, can you give a roll call vote, please, to call the question on the Planning Commission?
Sure. Commissioner Mann? Commissioner Amadeo?
Yes.
Commissioner McCarthy?
No.
Commissioner Jacobson?
Yes.
Commissioner Biala?
Yes.
Commissioner Bielsker? And Chairperson Burnett?
Yes.
Okay, well, Kathy was the only one that had her hand up. Well, let's go to City Council.
All right.
Roll call?
Yes.
Yep.
Is it? Okay. Councilmember Berkeley?
Yes.
Councilmember Utia? Absent. Councilmember O'Connell?
Yes.
Mayor Pro Tem Morton?
Yes.
Mayor Delgado?
No. Thank you, everyone. So that motion passes with myself dissenting. And so now we'll go back to the motion to receive the presentation we've heard tonight, and we'll start with the Planning Commission. Do you want to make a motion and a second on the Planning Commission, Commissioner Burnett?
Okay, a motion to accept the report.
I motion that we accept the report.
I'll second.
Okay, so we have a motion and a second.
And Aaron should be available.
Okay, Aaron, could you do a roll for the Planning Commission, please?
Certainly. Can you all hear me?
Yes. Good evening, Aaron.
Hi, good evening. All right. Let's see here. Sorry, I'm still getting my list up here so I can make sure to write it all down. All right. Commissioner Mann, is absent this evening. Commissioner Weekly?
No Weekly.
No Weekly either. Commissioner McCarthy?
Yes.
Commissioner Jacobson?
Yes.
Vice Chair Biala?
Yes.
Commissioner Bielsker? And Chair Burnett?
Yes.
And you can you please add Commissioner Amadeo to replacing Weekly? Thank you.
Wonderful. Commissioner Amadeo as well?
Yes.
Thanks. I'm so sorry about
that. For the Planning Commission, the motion carries.
Correct.
Mr. Mayor, and I'll ask the city attorney if I'm on the right track here. In the making of the motion, or at least for the city council, can we make sure we're capturing what you'd like to see when the document comes back to you? You know, the differences. We want to make sure we get it right since we're on this tight time frame.
Yeah,
and we could.
So to the city attorney, the request is to receive a presentation of the 2018 voter-approved cannabis for draft revisions. So can you speak to what the motion needs to include? Right now, it's to receive the
To
presentation.
receive the report is the action, but I think the council always has the ability to provide direction. And it probably, as the assistant city manager said, I think it would be good to know, since we are on a tight timeline, what the council would like to see us bring back.
So let's build a motion, Gail, and it's your motion.
Yeah,
Why don't you
so
start?
I think part of it was to Mr. Mandel's indication that as to moratorium, no moratorium, or a third or fourth alternative, that he was going to do additional research and help us to understand what's beneficial or what our alternatives are. So that would be part of a motion. And the idea
I'm sorry, Gail, let me jump in here and please excuse me. City attorney, we did have a call for the question to the vote, and now we're going on with discussion, which I'm in favor of, and I was in favor of. But can you opine, Bob?
Call for the question takes precedence, I believe.
Okay, then let's do a roll call vote, please, Matt.
Okay, Councilmember Berkeley,
Yes.
Councilmember O'Connell,
Yes.
Mayor Pro Tem Morton,
Yes.
and Mayor Delgado.
Yes, thank you, everyone. So that motion passes unanimously with both bodies. And I think that we are ready to adjourn. So thank you, everyone, for taking the time tonight.
Thank you.
We'll come back on this the next step. Thank you, everyone. Thank you, staff.